All right, on the issue of where we left, I'll admit 414 and 416. Let's see, an issue came up during the break about Larry King. And counsel had asked me to allow him not to appear tomorrow because his attorney's father was ill. And now I understand that her father has passed away.
That's what I've just learned, Your Honor.
But what I told you, just so it's clear, is that you fill up the space. He can come whenever you want him. I'm not telling him when he can come, when he can't come. But I want this court operating, not shut down, and I want that clear. We've shut down twice, now, for you. So you have your witnesses lined up, just like I made the DA have their witnesses lined up.
Yes, Your Honor.
All right.
If I may, Your Honor.
The next item.
Your Honor, if I may.
Yes.
Some issues have come up with regard to motions in limine filed recently, and as often as today or as current as today, involving certain witnesses we propose to call. And we have tried to work out some understandings in that regard, Your Honor, as we discussed in chambers briefly. We were planning to call an expert named Mrs. Minnow, and she would take a considerable amount of time. The prosecution has filed a motion to preclude her testimony and have said that if she is allowed to testify, they will be calling an expert in the rebuttal case. And we're trying to work things out like that. And it appears there may be a mutual agreement not to call either one, for example.
Okay.
So as Mr. Sanger did mention to the court earlier, we're trying to make sure the witnesses we call have a valid and clear and definite purpose. We're not just trying to call witnesses to make sure we have witnesses.
I understand.
And I want the court to know that. We're trying to pare things down.
Both sides do that, and both sides, you know, have to have their witnesses lined up. I said this from day one. And that means if I exclude a witness's testimony, right, then you still have to have a witness available to testify. So the burden on you is no greater than the burden was on the district attorney. If anything, it's less. You've had a lot more time since the trial started to have your witnesses lined up. I understand the fact that situations change, and I appreciate you're trying to do a good job with that, but we have to think about the fact that we've had a jury. We've taken them out of their lives. We've still got several weeks to go, and not using the times available, we've got law enforcement standing around in the outer areas. We've got all sorts of funds committed to this trial that, when we shut down, costs us, and that's why I strongly encourage you to keep the witnesses coming.
I understand, Your Honor, and we'll try to do that.
Okay.
Appreciate it.
And any of the matters that we're deciding that you don't want me to decide because you think you're trying to work something out, tell me. They're not really formal in limine motions. They're really motions that are just being made as quickly as either side can make them, and I appreciate it. What you're doing is giving me a heads up on an issue that's going to come up on an issue that I'm going to need to rule on, and that really helps me because we can spend the time to do that.
I was waiting for the opportunity to tell you that one of them is taken off the table with an agreement, and I'd just like to refer to that. It's the motion that was. One of them, I believe, was filed this morning by the district attorney to exclude the testimony of Mary Minnow, and Mr. Mesereau referred to that. I believe Mr. Snedden would agree. Part of their response was, if we called Miss Minnow, they would call their expert, and we would mutually agree to withdraw our expert on the agreement that they withdraw their expert. Obviously subject to some other change in circumstances, but basically.
That would be.
If we called another expert, for instance, that would change the ballgame.
Okay. Do you agree with that?
I do.
All right, then I'll accept the stipulation, and I will not make a ruling on those issues.
And I think that's what Mr. Mesereau was respectfully referring to, was that was a big hole for tomorrow, so we're doing our best to fill it.
Part of the problem here, too, is that I'm going to try to end early Friday. You know, we had Friday set aside as not going so you could go to your appointment, and now, because of the issue that has arisen involving the testimony of Garrigus, I've had to use that time. To the extent that we can finish Mr. Garrigus on Friday, then I won't expect you to call any more witnesses on Friday so that Mr. Sanger can go to the event that he had made a commitment to go to. But
thank you.
That means it's all the more important that we use today and tomorrow and Monday, okay?
Yes, sir. One other thing that might factor in. You said, quite a number of weeks, or, a number of weeks, something like that. We have pared down our witness list even more since yesterday, so things are going even more quickly, and I think it's safe to say that, a number of weeks, is probably an overstatement on the amount of time that we're going to be taking up, here.
Well,
Just to point that out. I'm not criticizing the court.
that's one place I would really like to be wrong.
Yes.
There's to overestimate when the trial will be completed. That would be great to be wrong.
We had talked generally where we were, and we have eliminated a number of witnesses since we had that discussion with the court.
Okay. Thank you. I know you're working hard. I'm not accusing you of not working hard to get this done. I'm just saying get it done. The James, let me see. Let me take up the next thing. What was I going to take up? We're not going to take up the Garrigus issue until Friday, because I believe he should be here and has standing to be involved in that. Take up the plaintiff's motion to exclude hearsay testimony of defense witness Michael Viner. I'll give you a tentative. Do you want a tentative, or?
I believe you already had, Your Honor.
I gave a sidebar tentative. Is that right?
You gave an open court tentative.
Open court tentative.
Yes.
All right. Does either side wish to say anything before I make a ruling on that issue?
I'm not sure what the court's tentative was on this one. You had given a tentative on two others. To grant the motion to exclude. Okay, yes, it was before we had filed the brief.
That's correct.
It was the same day that they filed.
That's correct.
So you have not given a tentative since you've had a chance to look at the transcript sites that we.
Correct.
Does that change the court's tentative?
Well, a little bit. You know, to the extent that this may apply to Larry King also, since he was, if I remember the testimony correctly, he was at a table with Viner or next to Viner, and they may have overheard the same thing. So to the extent that we're talking about the same conversation, then this ruling would be the same, you know. Apply to both of these people. And I think that the testimony would be, the part that I would allow would be that Mr. Feldman was heard to express opinions contrary to his assertion that anyone that said that he expressed opinions about his clients would be a liar. But I'm not going to allow the specific statements that are opinions of the credibility of the witnesses, accepting the DA's argument that it's improper to give opinions about the credibility of other people. And this is, I'm not going to let it in through the side door what I wouldn't let in through the front door. In spite of they opened the door. You know what I'm talking about?
Yeah. So may I respond?
Yes.
Okay, sounds like there's quite a breeze going through this house here. I understand the court's ruling. I'll just try to go right to the exact point that I think is the sticking point, and we'll see if it is or it isn't. I think the impeachment of Mr. Feldman is not just that he said that and just to show that he then said something different, that he did express opinions about a client's case in public when he said he didn't, but also to show, to the contrary of what the prosecution was trying to show on the merits of this, that Mr. Feldman's testimony was being offered to show that Janet Arvizo abandoned the case and that they were no longer seeking money, something to that effect. And that's certainly what was argued in the opening statement, and it was a fair interpretation of Mr. Feldman's testimony under direct examination by the prosecution. That he was saying, gee, you know, this case was given up because the Arvizos just didn't really want to pursue it. It is contrary to what we believe to be the case, and we have some other evidence on that. But in this particular instance, you have Mr. Feldman expressing an opinion indicating that he's not taking a case because he doesn't think they're credible. Now, for that purpose, it would be offered for, in that regard, not for the truth of the matter that they're not credible, so it doesn't go to the issue of credibility per se, which the prosecution is objecting to, but it does go directly to the contention of the prosecution that they, for some reason, had this contingent fee arrangement for a lawyer and they were not seeking money. I mean, it makes no sense, but that's their contention.
Your Honor, in the Simmons California Evidence Manual, it reads as follows. Counsel often mistakenly believe that if they allow the other party to admit objectionable evidence by refraining from making the objection, they will then be entitled to admit relevant evidence that is otherwise inadmissible. The so-called, open the door, or, open the gates argument is a popular fallacy. And it quotes a number of different cases including People versus Gambos and People versus Williams. The questions were asked by Mr. Mesereau on cross-examination. It was done for purposes of soliciting information that is not relevant to this proceeding, that is not material, and that is inadmissible for purposes simply because it's opinion, improper opinion, to then be able to set up an opportunity to be able to engage in impeachment. That's improper impeachment. You can't do that. In that regard, we're going to be asking that the matter be kept out in total. In total. We do not feel that any of that is admissible. One other issue we have to deal with is that I don't know if Mr. King actually is going to come, Larry King. But my conversation with his attorney, Kelly Sager, who is the attorney who represented Ian Drew in this proceeding, and I think the court remembers her contribution to this proceeding, unless they can show in advance that any of that statement actually was aired and published in the journalist's sense. In other words, it appeared on the television or in radio or newsprint coming directly from Mr. King. I don't believe Mr. King is going to say one word in this proceeding without Miss Sager standing up and yelling, and I suspect that the result will be exactly the same as what happened with Mr. Drew. And he is the witness to this encounter. And in the absence of that witness, I think it's one more factor for the court to put into this equation in terms of whether or not this material should come before the jury, because one of the witnesses, I suspect, will simply not be testifying based on the Shield Law.
May I respond to that?
Yeah.
And Miss Sager unfortunately is the person who lost her father just now. But I did talk to her day before yesterday specifically about this, and she said that this is not covered by the Shield Law. She agrees, because it was a conversation being had in a restaurant, and she is not objecting to Larry King's testimony as to this. She would object to anything we attempted to elicit with regard to any reporting that he was doing, but she agrees that this is not reporting. So I pass that along as being what she did tell me, and I believe she will show up or her partner will show up at the appropriate time and say exactly that. The other thing is that Larry King. We've got both Larry King and Michael Viner lumped together here. I believe Larry King is going to say that, something to the effect. I don't have the exact quote, but something to the effect that he was discussing the case, saying, she's crazy and all she wants is money. So it goes directly to the money issue as to whether or not Janet Arvizo is involved in wanting money. She says all she wants is zero. And Major J. Jackson says, all we want is zero, using the same terms. That is not evidently what they told Mr. Feldman, and it would run contrary to any lawyer's observation that Mr. Feldman is not going to take a case like this on a contingent fee if somebody doesn't want money. This, however, for the jury's purpose, is evidence showing that what he said is, in fact, contradicted by his own statements. And so we'd ask to admit it.
That's a little different than the problem I was having with the opinions as to his opinion that they were only in the case for money, as opposed to her saying, someone reporting. I guess he's reporting. That's double hearsay, right? He's reporting that Feldman said that she said? Is that how you're putting it now?
Well, I suppose that wasn't how I was putting it, but I understand the court's construction of that. However, the important thing is that Feldman said it, because Feldman on the stand said that wasn't the case. So let's assume for the moment.
Well, the question is, are you offering an opinion by Feldman that? Are you offering a statement that he gave an opinion that all she wanted was money? Or are you offering a statement that she said all she wanted was money?
I believe he will say she said that.
That's not what you have in your brief.
Well, the brief was very brief.
Right.
It was done very quickly.
The quote.
That's true.
You didn't leave any ellipsis in there.
The door was opened and it could have gotten away. Quite frankly, the brief was with regard to Viner, and now we have King. But anyway, that's what we believe that Mr. King will say. However, either way, I understand what is the distinction.
The safest way to handle this is to have a little 402 hearing before either of those people testify, so there's nothing, so that I know exactly what they say they heard.
That's fair enough, because we have been dealing through lawyers with them, and so I think that's a fair enough way too.
So you haven't had a one-on-one conversation? Okay.
That's not.
And I will instruct them, and I would like you to let them know, if I rule certain things cannot come in, They cannot blurt that out.
Your Honor, that statement is not completely true. I was having lunch at the grill one day in Los Angeles, and Larry King was there, and he told me that.
You were having lunch at.
I was. Larry King was there.
They can't hear you back there. You're.
Okay, all right.
We have not been furnished a report of counsel's conversation with this witness. And before it's broadcast to the press, I think we ought to be given a written comment of this.
They didn't hear you either.
I happened to be having lunch one day.
I have a request, Your Honor.
I deny your request. Go ahead.
At the grill restaurant in Beverly Hills. And Mr. King, I believe, came over and introduced himself and blurted out this statement. I then asked my investigator to follow up on it, and I have had no further discussions. The investigator has talked to Mr. King's attorney, I believe, and got from him what he's going to say, and that was a statement turned over. But I want to make sure the court knows what happened.
Thank you. So it would behoove all of us to start having lunch at the grill. Laughter. All right, we'll do that with 402 hearings.
Your Honor, if I may, just for the record, I didn't interview him.
Please use the microphone.
Okay, all right, I did not interview Mr. King.
I understand. He came over and voluntarily told you.
And I asked an investigator to follow up on it. Thank you.
Okay. The next item I'll take up is the James Newton. That was handed to me just a little while ago.
It's the people's motion, but if I could be heard, because I think I can focus the issue much more.
Yes. Go ahead.
It was just handed, and so therefore I don't have the document in front of me. And we obviously have not had a chance to file anything in writing. But the motion talks about a number of conclusions in the article that relate to the wrapping up of the Michael Jackson case, and there are quotes from Gil Garcetti and other people in there that the people object to. None of that is what we intend to introduce. There is a statement by Larry Feldman, a quote in the article. And I don't know if the court has a copy of the article there. I don't think it was attached to their moving papers.
It's not attached, no.
We can provide that. But there's a quote in the article, basically two different quotes by Mr. Feldman, where he was quoted verbatim saying that he was, in 1993. This is an article written in 1994. He said in the 1993-1994 case, that he was disappointed that the prosecution did not go ahead and prosecute, and that he would much rather have had the district attorney prosecute so that it would help him in his civil case. And Your Honor may recall that on the stand here, he said something to the effect, you'd have to be nuts to do that. You don't want to have the prosecution go first. So it's an absolute contradiction. That's the only thing from that article that we want to bring in. I'm paraphrasing this off the top of my head, but I think it's pretty close. There are two different quotes. They're in two different paragraphs, I think. But they essentially add up to what I just said. And that's the only thing we want to offer, and I think it's admissible for the reasons stated.
Okay.
First of all, Judge, there's been no verification with regard to what context that statement was made and when that statement was made. But if you look at the history of that case, as everybody knows it, the fact of the matter is that Mr. Feldman's case was completed and the money was already in the bank before we had ever finished our investigation. So the statement makes no sense at all. He had already obtained a civil settlement from the defendant prior to the time we had finished our investigation. The time of that press conference is not until 7 months later, after Mr. Feldman had already completed his case. So it has nothing to do with that statement. Nothing whatsoever. He couldn't be disappointed about anything. He's already got his money and he's already got his settlement.
Do you have the article? Have you seen it?
I had it. We got it last night we just saw it. Maybe it was this morning, I don't know. We just got it. And we immediately, it may have been last night we got it. But I don't have it here. I actually thought it was attached, but it's not.
Miss Yu has it on her system. She can print it out for you. Or perhaps she's got to go upstairs.
The timing of this makes no sense in light. It's attributed to him, and of course he was never asked about this particular statement at any point in time, so it wouldn't be impeaching.
Would you like to just see the screen, Your Honor?
That would be fine, if I can just see the quote.
Which quote do you want?
May I approach, or to deliver the laptop?
Yes. Do you want to look at this, Mr. Snedden?
I'm just going to scroll down a little bit and then I'll turn it around for you.
Okay.
Let me just make sure. Yes. Okay. I believe that's the quote we're talking about. Do you want me to take it?
That's fine.
Okay. Thank you.
Okay. I think what I'll do on that is, if you would give me a printed out copy, I'll look at Mr. Feldman's testimony, which I have in my office, and see how it fits, how the two things fit.
Yes, sir.
If you want to help me with that, Mr. Snedden, if you'd find the, either of you.
Miss Yu is getting you a copy.
I was just saying, I remember, at this point I remember the essence of Mr. Feldman's statement. I don't remember his exact statement, and I want to see, compare the two and see if they are truly inconsistent, which I need to do.
Yeah, it would have been easier to pinpoint the exact statement, but when I asked Mr. Sanger if that was the subject of the person's testimony, he didn't pinpoint that for me, so we just had to file the motion the way we did. Otherwise I would have done that beforehand.
Thank you.
And I apologize. If Mr. Snedden asked me that, I didn't get the call of his question. I certainly would have told him that that was it. So I apologize to Mr. Snedden for not making that clear.
Okay, the next one is, I just received, too, is another, Dexter Mason and Paul Krugman.
Yes, Your Honor. That was just filed by the prosecution. We can respond to it orally.
Go ahead.
Alright, understanding I've been working here instead of reading this over carefully, but it's a short motion and the thrust of it is the court has already made a ruling that the evidence with regard to J.C. Penney's is limited, and we have, in fact, tried to limit our testimony about that. However, these two witnesses, of the 20 or so that could be called with regard to that, these two witnesses go right to the heart of the J.C. Penney's testimony by Janet Arvizo and why it was fraudulent. And Dexter Mason was one of the security guards who was accused by Janet Arvizo of beating her and sexually molesting her on the ground and while she was up against a wall, and there was all that detail that we believe ties into a pattern that on at least 3 occasions has been demonstrated by Miss Arvizo. Allegations are made, false imprisonment, and then months later you come up with some kind of sexual thing. She did that to her husband, she did it to the J.C. Penney's people, and she did it to Mr. Jackson. Paul Krugman is a civilian. He's an individual who just happened to be in the parking garage, and he saw the woman, which would be Janet Arvizo, striking the security guards, and saw them simply restrain her. There was no sexual molesting. There was no kicking, pounding or bruising or anything else. We feel that in light of the credibility issues involved and the significance of this family litigating in unison and being deposed in a choreographed fashion to make out a case against J.C. Penney's, that it is relevant that we be allowed to at least bring in these two witnesses. Now, we had a bunch of other ones and we made the cut. And I'm assuming the court wouldn't punish us for doing that. We could have come in with 20 people and said, can we just call 2? But we picked the 2 that we think are appropriate on those issues. They will not cause a great deal of consumption of time, but I think it will be of significance to the jury in seeing the same pattern and understanding the significance of that pattern in this case.
What about, you were talking about Paul Krugman, right?
Yes, sir.
What about Dexter Mason?
Dexter Mason was one of the security guards who was accused of punching, kicking and molesting her. And he will not only tell you that, oh, thank you. Appreciate the court asking that question, because he will not only tell you that he didn't do it, but he will also say that the very next day, Janet Arvizo came to J.C. Penney's and, while she was facing criminal charges, she came to J.C. Penney's and hugged him and apologized. I think that's just critical testimony that confirms the same modus operandi to try to ingratiate yourself, as well as the modus operandi of proceeding seriatim to make increasing charges and claims resulting in sexual charges and claims when it comes down to trying to get something resolved in her favor.
Seems to me, though, that these two witnesses are just witnesses that end up doing exactly what I've been trying to prevent, which is to litigate all of the facts of the J.C. Penney case, and we had. I think you went beyond what I had ordered, and then the response by the district attorney was to bring in the pictures, the photographs, and now we're back on that. I'm not in favor of extending the J.C. Penney litigation here.
I understand the court's not in favor of it, and I'm trying to persuade Your Honor that we should do it anyway. I think it's very limited, and I think, the people did bring in the pictures. They widened it a little bit. I'm not saying the whole thing should be relitigated, But I think this is pretty critical testimony, particularly coming back the next day and offering an apology and a hug, and then once their criminal case is resolved, then they sue them and then escalate their claims. So I think it is particularly relevant. I don't think that it is going to open yet another door to some large relitigation, but it's a fair response to their showing pictures. It's a fair, I think, comment or fair evidence as to the hugging and the apologies and then the escalation of claims.
Your Honor, we didn't ask anything about the J.C. Penney's lawsuit in our direct examination. That was entirely brought up on cross-examination, and we dealt with it in a very limited and perfunctory fashion on redirect examination in a manner that we felt addressed the specific issues, and we did so in as limited a way as we could. The court indicated at the time that this motion was litigated, back, I think, in January, that we were not going to be litigating the J.C. Penney's lawsuit. If these two witnesses are called to testify, we're going to be exploring our options in terms of dealing with rebuttal witnesses and in terms of addressing exactly those issues. And this was exactly what we advised the court that we felt was going to be the problem with this type of thing. That we are effectively, once again, litigating a case that took place 6 or 7 years ago. We would ask that these witnesses not be allowed to testify.
All right, I'm going to rule that they cannot testify. All right, okay. The only other issue I think I have left was a memo about leading questions filed by the district attorney asking me to. Basically, I guess the position is that I have allowed leading questions on redirect by the defense. And you want me to quit doing that and chastise the defense for asking leading questions on redirect. Is that the essence?
I don't need the chastisement, but quit doing that, yes.
Let's talk about it a minute, you know.
Okay.
There's a lot of evidence in this case that's in. It's been in through umpteen witnesses, you know. 2 witness, 5 witnesses, whatever. And during direct it's brought out without leading questions. You do your cross, and then they come back and do some leading. And leading questions are allowed where it expedites the proceedings. They aren't required to lay a foundation, go back through every step. Neither are you. I'm sure they're as chagrined as you are sometimes when what is obviously a leading question I overrule. The law is not that you have to prohibit all leading questions. You know, you have to. The judge has to measure whether or not there's any loss of evidentiary value by a leading question. And if the evidence is in fact, I think the waste of time here is people objecting to leading questions all the time. It's, you know, it's a useless objection. Very seldom does it get you anywhere. Here's an example. Are the buttons on your sweater blue? And I get from both sides, objection, leading question. Well, what is the suggestion there? You know, answer, yes, or, no. It's a little different than, you are wearing a sweater with blue buttons, aren't you? It's a little different, and if you can't perceive that difference, then we got a problem. So putting words in a witness's mouth is a leading question. Asking questions that can be answered, yes, or, no, that are inconsequential anyway. The waste of time comes from the objection, not from the question or the answer. So I don't find your suggestion to be productive. I would still weigh each objection that you make on each of you. But, you know, I've tried whole cases where I haven't had as many objections as you all are giving me in a day. I mean, it's literally, you know, not to pick on anybody, but we had someone object to an answer that was in Spanish. No one knew what she'd said, and we had an objection. I mean, what, you know what I mean. Mr. Zonin, do you wish to say anything?
No, thank you. Laughter.
You're all doing a good job. I appreciate the hard work you're doing. Is there anything else to come before the court today? All right, court's in recess.
Your Honor, shall I use the term, open the floodgates? Laughter.
Oh, I'm sorry. Counsel, I forgot. My secretary just pointed out I didn't cover the Vinnie Amen issue.
That is true. That's on the list.
I can't tell from your points and authorities. I guess what I'm saying. Does this require a 402 hearing? No? Who's going speak to it?
Well, I will for the people, Your Honor. Have you received our response?
Yes.
It's our position that's dispositive of the issue. We are not going to. I think the question that was presented to the court and to counsel was that whether or not Mr. Amen had been granted use immunity. Two things are pointed out in our response. 1. The district attorney has no power to grant use immunity. It's something that the court can petition, or the district attorney can petition the court for a grant of use immunity.
Can you grant use immunity without petitioning the court?
I don't believe so.
Can you just grant it in your office?
I do not believe so.
Did you?
I know of no authority for that, and I don't know of any time that it's ever been done in our office. Every time that, in my experience as a prosecutor, we have sought use immunity for a witness, it has been through a petition. But secondarily, the fact remains that we have never given or agreed to give Vinnie Amen use immunity. It's predicated on his taking the stand as a witness for the people, and that discussion fell through.
It says he was offered, in the sheriff's report, it says he was offered use immunity.
Well, the lieutenant in that case is paraphrasing a conversation. And I'm not sure he's privy to the legalities of use immunity or exactly the discussion that took place. I can represent to the court that I talked to John Fahey, Mr. Amen's attorney, about this, to confirm that our understanding was identical. And he did agree with me, and that is what I placed in my affidavit.
Who's going to speak for the defense?
I am, Your Honor. I must admit, in the rush to do all these things, I can't find my moving papers. I've got their response, but
Do you want? I think these are your moving. Is the one with the sheriff's report attached to it?
Yes, thank you. I don't want to take it from the court if you need it. Thank you. First of all, Mr. Auchincloss was there. There is a tape of this interview, and Mr. Auchincloss was right there while this immunity was discussed on the tape. So it may be necessary to have a 402 hearing where we either play the tape or have Mr. Amen here. It would be nice to resolve this before flying him out from the East Coast.
When does?
We had hoped to call him next week, but we're waiting for a ruling on this so that we can, schedule him for a particular day. We could lodge the tape with the court so the court could listen to it. I don't know how. You don't have to listen to the whole thing. It's several hours. You could just listen to the beginning where they talk about it. The fact of the matter is, number 1, Mr. Auchincloss was there, so much for saying that the lieutenant doesn't know what he's talking about. Number 2, they very clearly gave Mr. Amen immunity. They told him that his lawyer was present, and there is no discussion about this is subject to us going to court and getting court approval. That's number 2. Number 3, use immunity can be conferred de facto by a prosecutor. It is true that the statute says that the court is ultimately the one to determine whether or not immunity should be granted. In other words, the order. The prosecutor can't give an order of immunity, because the prosecutor is not a judicial officer. That requires a judicial officer to have the order of immunity. However, effectively, a person can be granted and is granted routinely immunity, and in my experience, as opposed to Mr. Auchincloss's evidently, the immunity is granted routinely by police officers and district attorneys. Usually the district attorney's office is involved, is granted routinely to people. They're told, you have immunity. Come on, let's talk. That's what happened here. They have a lawyer, you have immunity and talk. What happened was Mr. Amen went through very patiently, very politely, as I think we heard he was, for I want to say 2.5 hours or maybe more, and answered all of their questions. They said they didn't finish the interview. They asked him to get some documents and bring them back. And he said, yeah, I'll go find the documents and bring them back. We have no follow-up report, so I don't know if he ever did that, but they asked him virtually every question. Mr. Auchincloss asked him questions himself. Mr. Auchincloss participated in the interview at great length, all under a purported grant of immunity. And were they to prosecute Mr. Amen and say, we're now going to use these statements against you, you can bet that his lawyer would be in here and say, Your Honor, he was granted immunity. And the court would say, yeah, Mr. Auchincloss, you sat there with the sheriff saying, you have immunity. Talk to us. You cannot use those statements. So de facto immunity was granted. What has happened is, Mr. Amen very specifically answered their questions about his interaction with Janet Arvizo and contradicted, not only contradicted, but explained exactly what happened, and explained things that, now we see from other evidence, were in fact true.
I'm going to object to counsel's paraphrasing the interview in a way that he perceives to be beneficial to his client.
Well, I don't know how else I would be speaking if I didn't deal with.
It's irrelevant to the discussion.
It is relevant.
There's an objection.
I'm sorry. There's an objection, so I'll stop.
Well, I'll give you an opportunity. I'm not going to sustain the objection. I'm trying to. I'd like to back up, though, to the point. Mr. Auchincloss, how would you like to proceed? There is a tape recording. Do you want to? It sounds to me like a 402 hearing is necessary.
We can do that if you wish, Your Honor. The issue is, though, that the agreement was reached before we went on tape. We went, as I recall. And I talked to Mr. Fahey about this, and his recollection is identical to mine. So the issue as to whether or not immunity was to be granted was conditional upon being called by the people as a witness. That was clearly the understanding. It was not just, we're going to grant you immunity, and whatever happens happens. So, you know, he's, of course, Mr. Fahey's on the East Coast, and I suppose we could, for the sake of convenience, conference him in some fashion into this inquiry. But I'll listen to the tape again. Perhaps that will. I mean, I haven't listened to it recently.
Okay. Just a moment. Discussion off the record at council table.
And that's, Mr. Sneddon makes a good point. We'd be happy to provide a declaration under penalty of perjury from Mr. Amen's attorney, Mr. Fahey. That may be handling the issue right there.
Your Honor, that's my point. It's not up to Mr. Fahey right now to make some judgment call. The people didn't evidently like the testimony. They offered immunity. That's our position. I believe it's sufficiently called out on the actual audio tape, because I got the audio tape before I got the report and I listened to the tape. And I heard that, and we'll get the tape so the court can hear it. I always say these things subject to, actually having the evidence, but I'm certain that it's on the tape to start with. So if that.
Why don't we start with that? Let me hear the tape, and then maybe I can see what's the best way to proceed from there.
All right, we will get a copy of that for you as soon as possible. No later than tomorrow morning.
Okay.
And I think, unless you want us to try to redact it, we'll give you disc 1. If I'm not mistaken, I think there's 3 discs. 3 or 4 discs, right?
I just want.
It's just, in other words, we'll give you disc 1, but, the whole thing. You don't have listened to the whole thing. You just have to listen to the beginning.
Just the beginning. You could leave a note if I need to. If there's several conversations, you leave a note and say, don't stop at the end of the first conversation, or something, that would help me.
Yes, sir.
If it's all in, once you get into that subject matter, it's all completed, I'd appreciate a note to that effect so I know not to keep going.
We'll give you the counter numbers, which should be the same.
Is it on a DVD?
It's on a DVD or a CD, a disc.
Since what's on the tape is only a portion of the discussion that we had, which was somewhat lengthy before the tape started, I would like to go ahead and submit a declaration from Mr. Fahey, with the court's permission.
All right.
Thank you.
We have a problem here with Mr. Auchincloss also, sort of testifying before this court as to what happened. We don't.
I understand the difference between attorneys talking and testimony. And when he submits a declaration, then I'll decide whether or not that's sufficient and whether or not I would allow you to cross-examine if there's some issue there. I'm not going to just accept. We're trying to see what's the least bothersome to everybody that we have to do. Whether we have to call him out here to testify, when maybe he's not going to testify. I don't know. So if you give me the tape and you give me a declaration, give it to the other side, and then we can make a decision as to where we go from there.
Very well, Your Honor. And we're hoping to call him. He's not under subpoena, but his lawyer has agreed to produce him as long as the court clarifies the immunity issue. Pardon me for sitting down. If I stand up, I'll be too far from that. And his lawyers agreed to produce him, so we would like to know as soon as possible so we could get him on a plane to get him out here, within reason.
With me, I'm saying we've got to move along. I understand we need to know the answer to this as soon as possible.
I will return the court's copy.
Thank you. All right.